Welcome to SCOTUScast, Health Insurance Reports and ERISA Preemption Edition. Thank you for tuning in. On December 2nd, 2015, the Supreme Court heard oral argument in Gobeille v. Liberty Mutual Insurance Company. Liberty Mutual Insurance Company operates a self-insured employee health plan through a third-party administrator. Vermont state law requires such plans to file with the state reports concerning claims data and certain other information. When Vermont subpoenaed claims data from Liberty Mutual's third-party administrator, Liberty Mutual sued and argued that the Federal Employment Retirement Income Security Act of 1974 preempted the Vermont statute. The district court found no preemption and ruled in favor of Vermont. On appeal, a divided panel of the U.S. Court of Appeals for the Second Circuit reversed and held that ERISA preemption did apply. The question before the court is whether the Second Circuit erred in holding that ERISA preempts Vermont's healthcare database law as applied to the third-party administrator for a self-funded ERISA plan. To discuss the case, we have John Ohlendorf, who is an associate at Cooper Kirk, PLLC. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. And now, Mr. Ohlendorf.
Last week, the Supreme Court heard argument in Gobeille versus Liberty Mutual, a case which concerns the really notoriously vexed issue of preemption under ERISA. So at issue in Liberty Mutual is a Vermont statute that requires health insurance companies to report information on the claims that they process into a comprehensive database of statewide healthcare information. And this Vermont law requires the reporting of really a wide variety of data on the claims that are granted by health insurance companies, including provider data, pharmacy claims data, eligibility data, and so on and so forth. It requires this reporting on a regular basis, ranging from quarterly to monthly, depending on the size of the company that's doing the reporting. And it requires that all this data be submitted in compliance with quite detailed electronic formatting and coding requirements. And all of this reporting is really designed so that Vermont can compile a comprehensive data set covering the provision of health care in the state, which it can then study in the hopes of improving the quality and cost-effectiveness of that care. Now, coming to the facts of this case, Liberty Mutual, the insurance company, provides medical insurance as a benefit to its employees, and 137 of those employees work in Vermont. And with respect to those Vermont employees, Liberty Mutual's health insurance plan is managed by a third-party administrator, Blue Cross and Blue Shield of Massachusetts. And Blue Cross is subject to Vermont's mandatory reporting requirements, which require it to report all of this information with respect to the claims that it grants while it's administering Liberty Mutual's health insurance plan. Now, because Liberty Mutual's plan is a self-insured plan, which means that Liberty Mutual pays the claims that it pays out of its own pocket rather than contracting with a third-party insurer to cover those claims, because it's a self-insured plan in this way, it's governed by ERISA. And ERISA was enacted in 1974 to regulate employer-funded benefits plans, including some health insurance plans like Liberty Mutual's here. And it was really designed primarily to ensure that these benefit plans, and in particular pension plans, are adequately funded and administered efficiently and for the actual genuine benefit of the employees that they cover. And ERISA does this through a variety of regulatory mechanisms, but one of them is by requiring the disclosure and reporting of certain information, mostly information about how the plans are funded. Now, ERISA is also designed to ensure that the regulation of the benefit plans that it covers, at least on some issues, is uniform, so that these plans aren't subject to really a confusing tapestry of conflicting state-by-state regulations. And to that end, ERISA contains a preemption clause that's worded very broadly. It purports to preempt any state laws, quote, insofar as they relate to any employee benefit plan, close quote. So this is really expansive preemption language, and the Supreme Court has had several occasions to interpret that language, and the course of these decisions interpreting language have been somewhat uneven. So initially, in its first encounter with this language in Shaw versus Delta Airlines, the court interpreted this preemption clause really quite broadly, saying that basically when it says it preempts any plans related to covered benefit plans, it means what it says, and insofar as any state law either refers to an ERISA-governed plan or has a connection with an ERISA-governed plan, that state law is preempted. In 1995, however, after a couple of other encounters with the preemption clause in between, in a case called Travelers Insurance Company, the court really cut back on Shaw's expansive gloss on ERISA's preemption language. And Travelers refocused the inquiry away from what it called Shaw's uncritically literal question of whether a state law is connected to an ERISA-governed plan, and towards an inquiry that compares the purposes of ERISA and the purpose and effect of the state law in question. So in this case, Liberty Mutual didn't want its third-party administrator, Blue Cross, to report information related to the claims under Liberty's plan. And so it brought an action for declaratory and injunctive relief, hoping for a holding that Vermont statute was preempted by ERISA. The district court sided with Vermont. The Second Circuit reversed the district court in a split decision, and then ultimately the Supreme Court granted Vermont's petition for certiorari. On cert, the core of Vermont's argument is that Travelers requires this contextual look at the purposes of state law and ERISA, and while Vermont certainly grants that ERISA also contains significant reporting requirements, the purposes of the two different reporting schemes Vermont suggests are very different. So ERISA, at least as originally conceived, is primarily concerned with the financial aspects of plans. So the reporting that it requires, has to do with how plans are funded, whether they're solvent, that type of thing. Vermont, by contrast, is interested really in healthcare policy, so it's requiring the reporting of that type of data on the claims that are granted. In response to this, Liberty Mutual homes in on another purpose that is behind ERISA, and that's this goal of protecting the insurance plans that ERISA covers from a multiplicity of cross-cutting regulatory schemes. So, as Liberty points out, if Vermont can require reporting all of this information, so can the 49 other states. And the result will likely not be sort of a uniform scheme that every state adopts. The result is going to be a patchwork of regulatory schemes, each with their own sort of idiosyncratic requirements governing what type of data needs to be reported, how it's reported, when it's reported, etc. So after the oral argument last week, I think we're able to predict how at least some of the justices are likely going to vote. So Justices Scalia, Alito, and interestingly Justice Breyer seem to some degree or another inclined to side with Liberty, although Justice Breyer's reasoning seems to be taking him in a little bit of a sort of a middle direction. Justices Kagan and Ginsburg, and to some extent Justice Sotomayor, on the other hand, seem inclined to side with Vermont, essentially on the reasoning that the reporting requirements here really aren't all that onerous. But the rest of the justices, I think, are hard to read, so we really don't know enough to be able to count to 5 either way. So rather than speculate about how the case is ultimately going to come down, I want to close by instead commenting on what I think this case says about the state of this corner of the court's preemption jurisprudence. So as I mentioned earlier, there's been this well-known shift in ERISA preemption law from Shaw and Shaw's sort of focus on the plain text and the very expansive text of ERISA's preemption clause, and then through Travelers away from this textual inquiry. And the story here is basically that, people say the court recognized that this related to language in ERISA's preemption clause is just not helpful. And so the court focused back on the purposes behind ERISA and adopted this more contextual approach in Travelers. Now, interestingly, this trajectory from the plain meaning of the statute to a focus on purpose sort of runs in the opposite direction from the trajectory that the court's general statutory interpretation jurisprudence has really traveled in the last 30 years, really during the same period. And there, as is well known, the court since the 80s has really quite noticeably departed from relying on the broad purposes behind legislation in favor of a close textual analysis of each statute. And for that reason, I think a lot of commentators who are opposed to this move in general statutory interpretation, this move towards textualism, really hold up ERISA preemption case law as sort of a case study in why textualism can't work, why, in this area the court has recognized that it has to turn back to purpose. But I want to close by suggesting that this case, among a lot of cases, I think, shows why the courts turn away from ERISA's text and towards purposivism is just as likely to fail as the approach that it had adopted in Shaw. And it's likely to fail for precisely the reasons that textualism has gained ground generally, I think. It's precisely the flaws that textualists have pointed out in the purposivist approach. So recall that Vermont is essentially arguing in this case that its statute's not preempted because the purposes of ERISA's reporting requirements aren't really at odds with the purposes of Vermont's statute. But as is almost always the case, Liberty Mutual is able to come back and parry this by pointing out that there's another purpose underlying ERISA, and that's Congress's desire for uniformity across the board. And this move, this parade of sort of general purposes that to some extent cut across each other, is precisely why textualists have been arguing for 20 or 30 years that relying on the broad purposes behind legislation and interpreting that legislation is just too indeterminate an endeavor to be all that helpful. Because the fact is that a complex statute like ERISA is always grounded in a variety of purposes that are often cutting across one another. And that suggests to me, and this case suggests to me at least, that a test for ERISA preemption, like Travelers, that is keyed to the purposes behind ERISA, is not any more likely to, in the end, yield tractable results than a test keyed to ERISA's admittedly indeterminate text.
Thank you for listening to this episode of SCOTUScast. For more episodes of SCOTUScast, as well as audio and video of past Federalist Society events, please visit our website at www.federalistsociety.org/multimedia.